My cat has a hard time understanding what he wants in life. Look at him. Ain't he cute? But he's up. We're up in the middle of the night. I don't want to give him anything to eat because I don't want him to be spoiled in that way. But he does love affection and he does like to go out at odd times of the night. So now he's trying to get away. Where you going? All right. All right. He wants me to put him down. So I put him down. Mr. Ron, he's quite content to just be right down there by my feet. Doesn't appear to want to go outside, just wants to be kind of massaged and rubbed. And just, I never thought I'd be a cat person, but I kind of like him. All right, so basically, as I was saying, I was talking about, I forgot the name of the class, but I ended up uh, researching the case UC Davis versus Bach, Bakke, which was one of the first meaningful cases concerning affirmative action, whereby uh, it was kind of a split decision, but it was one of the first, what you want to say, dominoes to fall towards the ending of affirmative action. This was the first step, and it took place back in the 70s. And just like during the civil rights movement from the 50s up and through the 70s, civil rights organizations and activists would often look for laws that were that they felt were unconstitutional or violated their civil rights, and they would violate those laws and do so in such a way that they could bring a lawsuit to challenge the law. And if they were able to provide an effective defense, they could win the case, and from that point on, declare the law unconstitutional and kind of have it overturned. It's the same thing that I'll call the other side white supremacists, conservatives, Republicans, some Democrats. The label is not really that important. The ideology is what I'm going to be focusing on. It was a uh, it was a very interesting case in that I found Mr. Bach to be a quite honorable gentleman, served his country in the Marines, was a combat medic. And after his service, he wanted to go to med school and become a doctor. And it seemed to make sense. And he had applied to numerous medical schools, 10 or so, and had been turned down. And coming up on the 11th time was at UC Davis. He pretty much had been resigned to his fate. He'd been turned down. And now the interesting part is he wasn't turned down because he wasn't academically qualified or competent. Back then in the 70s, medical schools wanted their doctors to be young. So it was uh, well known, well practiced age discrimination. He was 30 years old, and they didn't want their doctors to be starting med school at 30. They thought that was too old, and he knew that. So UC Davis, as I mentioned before, just like looking for cases, you have these groups looking for cases to begin the process of overturning affirmative action, which was, basically race as a consideration in admissions to make up for the fact that race was a consideration in admissions negatively. So, with that in mind, uh, basically, Mr. Bach, upon being turned down for admission, An administrator, very interestingly, recommended, gave him the business cards of a couple of lawyers and recommended that, maybe you should apply again, but maybe you should talk to these gentlemen first. And, given my personal experience, having tried to get into a graduate school and got turned down, they didn't provide me any information about lawyers who I could contact if I felt like this was unjust. So that was strange in itself. And later on, you'll see that that administrator was eventually relieved. However, back to the case at hand, what usually happens when these things happen, usually with law school, uh, somebody files a case, say they were discriminated against because they were white, because of affirmative action, because of quotas set aside for minorities, and yada, 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 and all that, you know, sugar, honey, iced tea. Uh, well, usually what happens is they let the person into law school while the case is working its way through the courts. Uh, the student is matriculating, eventually getting their law degree, and at that point, the case comes up on docket and is now moot because the person has what they were seeking. They have not been deprived of the opportunity to go to law school. This wasn't the case for Mr. Bach. They turned him down, and then on the 12th time when he went back, they turned him down again, and they didn't let him in. So this made the case go further and further from municipal to state to eventually to the Supreme Court. And it came down to basically a split decision, which was using race, affirmative action, using race as a consideration in the admissions process to make up for the fact, the historical discrimination of the past. They said that's okay. However, you can't set aside a specific number of seats. You can't use quotas to accomplish that. So it was a split decision, justices on both sides. And basically, Mr. Bach went to medical school and became a doctor and lived, I assume, happily ever after. Never wanted to discuss or get into it. Basically, it was his situation was used for political purposes, in my humble opinion. However, I digress. Have a good evening.